Thank you so much. I'm Teddy Downey. I'm the CEO and Executive Director here at the Capital Forum. And, we love having these rigorous discussions in advance of antitrust litigation. It's one of the most interesting and I think fun. I mean, I don't know, not many people think antitrust is fun, but I think it is. So let me, Nate Soderstrom, our senior correspondent, one of the co-heads of our antitrust team, is going to speak with John Kwoka. Let me say a few words about John. He is the Neil Finnegan Distinguished Professor of Economics at Northeastern University and a research fellow at the American Antitrust Institute. He's taught at the University of North Carolina, Chapel Hill, GW, and has served at the Federal Trade Commission, the Justice Department's Antitrust Division, and the Federal Communications Commission. And from my perspective, I would just say that John, having known him over the years, he's really just unafraid to push back against what I would call kind of established status quo thinking among antitrust lawyers and economists when he finds evidence to contradict the status quo. And I've been looking at this space for a long time, and I think that's a rare thing, and I think he should be celebrated for that. And, so in addition to that, I appreciate him and his work in large part, not just because he's courageous, but also because it's evidence-based and rigorous. And that's what we like to push for among our reporters here at the Capitol Forum. And also, I should say that in 2005, Professor Kwoka published Mergers, Merger Control, and Remedies, a retrospective analysis of U.S. policy. And there's really no doubt in my mind that this has been one of the most influential pieces of antitrust research that I've come across. It's just incredibly influential. It has been incredibly influential and has really shifted the debate. And the agencies themselves have taken it extremely seriously. And if I can summarize it quickly, I think the two big findings were that, one, a lot of mergers that the agencies had cleared did end up having price effects. And two, that behavioral remedies in particular were ineffective or largely ineffective. And so that's, you hear that all the time now, and this was the evidence for that. And I also want to mention that Professor Kwoka has done some work on the Sprint T-Mobile merger. He authored a note for AI entitled Masquerading as Merger Control, the U.S. Department of Justice settlement with Sprint and T-Mobile. He also submitted Tuniac comments along with a number of other economic professors urging the court to reject DOJ's settlement as failing to address the competitive harm alleged in the complaint. I also want to note, and I think this is interesting, Professor Kwoka served as one of DOJ's economic experts in its 2017 lawsuit to block AT&T's proposed acquisition of Time Warner. And so with that, I'm thrilled to have him, and please give him a round of applause.
So I am Nate Soderstrom. I'm senior editor of the Capital Forum, and I'm, of course, thrilled to be here today with Professor John Kwoka. So just to set the stage, in April 2018, T-Mobile announced an agreement to acquire Sprint in a $26.5 billion transaction, coming to two of the four facilities-based U.S. mobile wireless carriers. So as you would expect with a deal like this, quite a bit of antitrust and regulatory scrutiny. In May of this year, FCC Chairman Ajit Pai said he would support the deal subject to conditions. In June, a group of state attorneys general sued to block the merger in the Southern District of New York. And then in July, DOJ's antitrust division announced that it would challenge the merger, but it also secured a settlement through which Dish, a satellite TV firm, would replace Sprint as a new number 4 in the U.S. wireless market. The settlement, however, has not won buy-in from the now 16 attorneys general who are suing to block the deal. Trial in that suit is set to kick off December 9th. And that's where we are. So, John, DOJ's remedy is complicated, a lot of moving parts. The highlights are that Dish would acquire Sprint's prepaid business, which has about 9 million customers, would also have the option to purchase Sprint Spectrum 800, as well as decommission cell sites and retail stores. Dish also has a 7-year MVNO agreement with new T-Mobile that allows Dish to basically lease access to T-Mobile's wireless network as Dish builds out its own. A lot of moving parts. John, to bring you in, I wonder if at the outset you could talk high level about your thoughts on this remedy and in particular your concerns that it may fail to restore competition in the mobile wireless market.
Sure. I'm delighted to be here. I want to thank Teddy for that overly generous introduction, which I can hardly live up to. I hate introductions of that sort. The rest of it's downhill from here. So let me try to respond to your question, Nate, which is to talk about this case and about the remedy in particular from a high-level view. So the background, of course, is that there are 4 wireless carriers. There's been general agreement, and the DOJ has been consistent about this, that 4 is a necessary number. That was their position 8 years ago when AT&T tried to acquire T-Mobile. Everyone's been trying to acquire T-Mobile, it turns out, and it's their stipulation and the foundation for their case, and all of the file documents here as well. So the merger, obviously, between Sprint and T-Mobile would require a 4th firm to emerge from somewhere. This is why the remedy, this is why I chose to comment on the remedy, because it's really the fulcrum on which this entire case, I think, hinges. And it is because the remedy is is the supposed solution to the competition problem of needing a 4th competitor. So we'll talk a little bit about the details of the remedy, but in short, the remedy, as you say, has lots of moving parts, but it's really a jigsaw puzzle. Some of these piece parts are more visible and likely to occur and others not, whether they all fit together and as a result turn Dish into an effective nationwide wireless competitor of the sort that's being lost is the question, and it is DOJ's representation that that will be true. So suppose all the piece parts work. Just to fast forward, if reading the remedy and anticipating how DOJ envisions this unfolding, Dish will become an effective replacement for most of the country, perhaps not quite all, but most of the country, with 5G spectrum and with retail stores and with prepaid operations and with all the rest. But that won't happen for 7 years. So in reading that by itself, one might say, well, this remedy fails to meet the relevant standard. The relevant standard is not when in some distant time period a new competitor might emerge and to think about what's required in order to make that happen. The standard for an effective remedy is something that replaces the competition that's otherwise lost as a result of the merger. So we need a plausible and predictable remedy. We need a plausible and predictable solution to the competition problem. And I submit that this remedy is not that. And it's not that on its face, because under the best of circumstances, the one that I think is overly optimistic in any case, we're waiting till the middle of next decade before the competition is replaced. And in the meantime, we will be much closer to having the 3 wireless competitors than 4. And the 3 wireless competitors, DOJ itself says, will result in a parade of consumer harms and harm to competition. So that's the concern. And again, we're going to talk about the details, but even on its face, it seems to me it fails to meet the standard of preserving competition.
Perfect. And we'll get to this kind of transitional question in a bit. Just to take maybe a bit of a step back, DOJ has said that, quote, the overall objective of the remedy is profoundly structural, as it is designed to stand up a 4th nationwide facilities-based wireless carrier. On that question, how do you evaluate DOJ's statement that the fix is fundamentally structural? Because there's clearly a significant structural component. The goal really is to create a new number 4, restore pre-merger market structure. So given that goal, do you still disagree with DOJ's assertion that, I guess, the means to get there is structural in nature? That's a structural remedy.
So I have 2 answers to that. One, of course, is ultimately less important what we call it than what it will accomplish. But since DOJ has stuck out its chin by advancing the proposition that this is structural, it said that to begin with, and then it's reiterated that more strongly, let's take a look at whether this is structural. So what is a structural remedy? Structural remedy, classic structural remedy, truly the simplest case, but a classic structural remedy would be 2 multi-product firms that overlap in one product. They spin off that one of the 2 overlapping products to a freestanding entity, or more likely another company that has similar operations where they can integrate the new division. That's not what's going on here, not by a long shot. Calling prepaid a structural divestiture overlooks the fact that really it's rebranding Sprint's prepaid services for quite some time. There's a schedule or a calendar by which Dish would start to provide its own services, but its customers and employees, a business operation, not concrete and steel in the ground, not the infrastructure to manufacture the service that's being divested. It is simply rebranding in the short term. So that's not, and prepaid is a high churn business. It's a low profit, high churn business. Customers can melt away. Employees can decide they don't like the new management or operation and disappear. This can evaporate pretty quickly. I'm not saying that there's any reason to suspect that, but that's just to indicate it's different from an ongoing, plant or production or product that has fixed and sunk costs attached to it. But to repeat, there's a couple other divestiture components which we can talk about, but none of the others are happening anytime soon. But what's really important to hear is not the label we put on it, but why it is we want a structural resolution wherever possible, and what the danger is of a conduct type remedy. So a structural remedy, my classic case of cutting loose one of the overlapping products, means that once that's done, and there are some tricks to that, there's some pitfalls and tricks, but once that's done, the market looks a lot like the market before. The same number of independent competitors without any ongoing interdependencies. Every one of them has their own profit incentive. There's no compromise in their relationships that gives them the opportunity or incentive to undermine each other's operation. They are as independent as the operations were pre-merger in the classic case. That's not what's going on here either. Even in the prepaid business, Dish will be dependent entirely on contractual arrangements with the new T-Mobile for provision of the background of the service. It will also, Dish will be dependent going forward on transition services, as they're called, call centers, customer service, SIM card procurement, and other things as well. So all of that, other than the customer-facing piece of the business, will continue to be provided for some period of time by T-Mobile, with a whole host of provisions in the order as to how the transactions are supposed to unfold. Good faith, prompt, reasonable access, those terms litter the stipulation and order. And those are the terms that give rise to conflicts. And they also give rise to the ability of the ultimate provider, the new T-Mobile in this case, not to act in good faith or to act in ways that are obviously or necessarily in good faith, but to have an apparent reason, a pretextual reason for doing so. These are the sort of issues that trigger ongoing engagement between the parties and ongoing conflicts that have to be brought to the court or to DOJ for resolution. And that's the essence of a conduct remedy, is that the incentives of the parties are not any longer clear and sharp. And in particular, the incentives are to raise rivals' cost or to somehow compromise the ability of the divested assets to operate in a fully effective manner as a replacement competitor.
Right, and I know the agencies typically don't like ongoing entanglements in here. There may be one. So I think a couple ways people might push back on what you said. The first is that any structural remedy is going to have some element of transition services, supply agreement, short-term monitoring. You can't transfer assets instantaneously. Therefore, it might be short-term, but there's some kind of transition that has to happen. We're generally okay with that. And here, there's a transition. Maybe it's a bit longer, but okay. The second, and I think it's related to that, is you have to tailor these fixes to the industry. Here, for Dish to build out a wireless network is going to take a number of years. You can't bring in a new number 4 from day one. So I guess the argument is DOJ seeking to restore pre-merger market structure, there is some transitional element associated with that, but you have to tailor the fix to the industry. And therefore, that's why we have something here, which, as you said, it takes a while. It's not instant. How would you kind of respond to those ideas? Basically, the idea that any structural remedy has to have some, at least short-term behavioral or transitional component.
So again, the classic divestiture remedy, oftentimes there'll be a monitor or trustee to ensure that the assets are transferred as ordered. There also is the requirement that the agency, FTC or DOJ, do due diligence on the components of the product or business that's to be transferred. There's also, on the basis of some adverse past experience, the agencies understand the need to transfer an entire operation as opposed to simply some portions of it. So all of that, that certainly does mean, as you say, that there are some issues that need to be addressed even in the most conventional, simplest of remedies of a divestiture sort. But once those boxes are checked and the divestiture is consummated, if you do all of those things in advance relatively well, the agency gets to walk away from the market. There's no need for ongoing oversight other than, the possibility of other anti-competitive actions on the parts of the entities, but not as a result of the merger. There's nothing any longer that involves or requires the oversight of a court or the agency, because again, the divested entity is whole unto itself and is capable of operating as a freestanding, profit-maximizing, uncompromised way. And that again is certainly to agree that there are some pitfalls and there are some dangers if one doesn't do the divestiture correctly, and there is some transition phase. But the divestitures that have been accomplished, the true divestitures that have been accomplished, really do allow for the agencies not to be deeply involved, or certainly not involved in an ongoing way. And it is because, as an economist, I and economists will believe that once the market structure is reestablished with the same number of entities, all capable of doing post-merger what they did beforehand, then the model says that we should anticipate similar outcomes. And that, again, is not the case for a conduct remedy. This one, again, pushes the boundaries. This is not, I've been involved in lots of cases that have involved remedies of a variety of sorts. And you're quite right, some of them involve some mixture of the two. But this really, if there's a frontier past which we ought to be cautious not to go, this one has cleared that frontier some time ago and is way out into the tall grass here. And it is because we haven't quite gotten to those details, and maybe not. You can read on the various places where my lengthy, longer critique is publicly posted. You can see all that. But there are various parts of this that I think defy reasonable expectation for how they are going to work.
Fair. So, look, the Dish fix is admittedly complicated. I think the argument for it is something like this. Dish is sitting on a ton of spectrum. By bringing them in, you get the spectrum off the sidelines, you get it into use for wireless services. And you're giving them a real head start. So 9 million subscribers through Boost and Virgin, up to 20,000 cell sites, 400 retail locations, option to buy the 800 from Sprint. And in the interim, they have a favorable MVNO agreement, so maybe they attract subscribers that way. I guess the point is, so Dish has existing advantages relative to, I guess, any other entrant that could come in and buy this package. They're probably getting a sweetheart deal coming in, good terms on what they're buying. Given that, I guess, is there a decent chance, as the Assistant Attorney General said, Dish could actually expand output, make this market more competitive if things work out? And if that's the case, does that mean that this is maybe a risk that's worth taking for DOJ on this settlement?
So I'm sure nothing else I say here will ever see the light of day. But I sort of view your story and the remedy story, as a story. It's not really a remedy to the factual problem before us. It's a story. It's a story about how all of this might happen. And someday, 2026, we can reconvene and see if this is true. There will be such a fourth competitor out there. Compared to a pizza parlor starting out. This does provide Dish with some inputs which are necessary, but Dish is not a wireless provider. It has no presence, no experience in this business. What the remedy purports to do is to have it nonetheless amass the financial and operational and legal and construction resources to build out an infrastructure from coast to coast to absorb or to utilize 20,000 cell sites, hundreds of retail stores, which, by the way, which ones get divested is up to the merged company. If there are nearby or adjacent ones, we know which one will be decommissioned by the merged company and handed off to Dish as the new competitor. But all of this is part of the story of what has to happen in order for this to occur. And reasonable people can disagree about reasonable things, but it seems to me that this does not plausibly and predictably lead to the outcome that the Justice Department wishes it would. It is a story, not really a hard-edged, objective, and plausible business proposition.
One other point of pushback on that, one point of potential pushback, is the original transaction itself. So T-Mobile and Sprint. There must be some efficiencies from that deal. You have one 5G network, not two. The spectrum's complementary, the 600, the 2.5. Like, there should be some level of efficiencies. DOJ concluded that they don't outweigh the competitive harm, but we can see there's some efficiency benefit from this. To the extent that's the case, and they're just not quite enough to outweigh the harm, I mean, is this maybe exactly the scenario where we'd want to pursue a big fix, where, look, the original transaction, decent efficiencies, don't quite outweigh the harm. Let's bring in a new number 4 and still benefit from that original transaction while remedying, hopefully, some of the anti-competitive harm. It's not the exact story, but you get my point. Is there an argument to be made there we need to take into account or give more weight to the efficiencies from the main event transaction?
So most mergers produce some efficiencies. There's no doubt about that. The guidelines are written and were originally written to anticipate and include the idea that there would be some modest amount of efficiencies from most mergers. Inevitably, avoiding duplication gives you something along those lines. What counts more heavily in the guidelines, of course, is there are efficiencies in terms of marginal cost savings, because those are more likely to flow through to price reductions and consumer benefits. But the DOJ, in its filing, said, as you rightly point out, Nate, that these, upon their own assessment, did not outweigh the competitive harms here. For efficiencies to count, as everybody here knows, they have to be verifiable, and they have to be merger specific. The marginal cost argument, I would say, is more likely to have been verifiable, and DOJ determined that those savings, whatever they might be, were not really adequate. The merger specific nature is a little hard to assess because we don't have much of a record in this case. But it's pretty clear that anticipating an entirely different marketplace with somewhere down the road 5G being deployed, doesn't really represent the kind of foreseeable efficiency that's uniquely attributable to this merger. After all, we have 4 wireless carriers now, and all of them, including Sprint and T-Mobile, had declared prior to the merger announcement that they were starting to deploy 5G. Would it be faster if they combined? By the record. I might add that, in 2011, when AT&T sought to acquire T-Mobile, this was reviewed both by the FCC and DOJ, and the FCC put on the record a substantial amount of the analysis and the evidence that they use in order to assess the efficiencies from more rapid deployment of 4G at that time. And so if you look back on that, it's interesting reading because, here was a merger of two of the four wireless carriers with unarguable anti-competitive effects by themselves, supposedly to be rescued by efficiencies, and efficiencies of very much the same sort. More rapid deployment, faster realization of economies of service benefits to consumers, and so forth and so on. And what the FCC did was to take apart the filing on the part of the parties at that time to examine exactly what the source of the supposed economies were from relieving congestion and more rapid deployment of 4G. And what is apparent from my reading of it is that it takes a lot of work in order to redo the engineering studies that go into this kind of analysis. It's not the sort of thing that is at a quick read you can decide whether it's verifiable, implausible, or not. The FCC basically redid the reengineering and found as a result that embedded in the analysis was an assumption about the way that congestion costs arose and how they would be remediated as a result of pooling the two companies' resources. And the assumption was completely implausible. I mean, it purported to solve the problem, but in an extraordinarily expensive way. And as a result, only a tiny fraction of the relieving of congestion benefits in that merger were actually allowed as verifiable and attributable to the merger. So I don't know what the case is here. I don't know what DOJ did in this case, but again, it seems to me that these are benefits, if not quite efficiencies. There's benefits of the sort that, if they do arise in a much more speculative way down the road somewhere and are much harder to evaluate and much harder as a result to be attributable to the merger, much harder to satisfy the merger guidelines requirement that efficiencies to be recognized are uniquely attributable to the merger. So do I know what the answer to that question is? Of course I don't. I haven't seen the record, and I don't know what DOJ did to take peel the leaves of the onion apart to see what lies at the core of the critical assumptions. But again, I've been involved in way too many cases where the benefits are speculative investment and deployment and advancement of technology arguments, which of course are much harder to evaluate, much harder to prove, much harder to disprove than traditional economies having to do with combining operations and saving fixed or marginal costs. But they need to be handled, I think, with considerable care, because the earlier wireless merger, the earliest effort to undertake a wireless merger, certainly fell apart on closer inspection of the purported deficiencies.
And then I think this might be my last question, but just to be a bit forward-looking. So you've been involved as an economic expert in antitrust litigation before, including in DOJ's challenge to AT&T's proposed acquisition of Time Warner, I should say, completed acquisition, where you're scheduled to testify for the government, I believe in part on why the proposed remedy was overly behavioral and wouldn't restore competition, how things change, but didn't ultimately take the stand. Wonder from your perspective how you see this remedy question playing out in court. Obviously, the states are going to hammer the fix. The defendants are going to defend it vigorously. So as far as the experts exchanging reports, even getting on the stand, how do you see this playing out? Just given everything we've talked about, what do you think ultimately proves persuasive to a judge on this particular question of evaluating the remedy?
So I wouldn't propose to anticipate exactly how that might unfold. That's beyond my competence, I'm afraid. But it's going to be an interesting case for one, I think, reason that's front and center, and that is that by itself, there appears to be very little room for the parties to argue that a 4-3 merger would not produce harms. That seems clear from everything that the Justice Department has asserted, and of course, is arguably is implied by the parties' agreement to attempt to resolve that in the order. And so, as I said at the outset, the issue that much of this hinges on is whether the remedy really fixes that. And again, as I said at the outset, this is the settlement, as I read it, is a story. It's a Hail Mary pass, if you will, to see if this can be fixed through some miraculous catch in the end zone. But if you look, at the piece parts, they lack the kind of plausibility element that I said before. And I think that the judge would, be in tune with arguments about whether the fitting of the piece parts together, as I called it, a jigsaw puzzle, really sounds like it has plausibility. And in addition, as I said also at the outset, there's the Justice Department's own argument is that this remedy, even if it is a Hail Mary pass caught in the end zone, it won't land until 2026. And I think the parties may have some difficulty, DOJ and the parties may have some difficulty in explaining why the intervening time doesn't by itself represent harm to competition of the sort that a true remedy would not tolerate. So in that sense, I think that, unlike a lot of cases, or in the Tunney Act as well, there's a fair amount that the opponents of this remedy and opponents of the merger can use to push back on it. On the other hand, someone asked me this before, I've long since abandoned the business of predicting how cases will come out. And so I think that we'll all have to wait for a bit on that one.
John, thank you very much. This was great.
Thank you.